to the declaration of the Kpandai parliamentary seat vacant. Now, the move has sparked chaos in the chamber, with the speaker struggling to maintain order. The protest has, brought parliamentary proceedings to a standstill, with tensions running high as the majority and the minority clash over this particular matter. Now, this follows the Clerk of Parliament's letter to the Electoral Commission directing it to conduct a rerun of the Kpandai parliamentary election as ordered by the Tamale High Court. Now, the court, in its November 24 ruling, annulled the December 7, 2024 results after a petition challenging some anomalies in 41 polling stations. Now, the clerk on Monday formally notified the Electoral Commission that the seat is vacant pursuant to the ruling by the Tamale High Court. The move sparked huge protest from the minority, and even the party itself, the NPP, has today spoken on this particular matter. My colleague James Kwesiaviji has been in the House monitoring proceedings and joins me on the line with more. James, how did this particular action start?
So, right after the vote and proceeding of the day, we speak, Honorable Bernard for what. Right after that process, the Speaker called for the leader of the House, who is Honorable Mahama Yariga, to guide the House on what is before the House for today. Then at that point, the minority chief whip, Frank Anodompe, rose to his feet and prayed the Speaker that they go to item number 8 on the order paper, and he prayed the Speaker to allow him come under order 43 of the House, which allows for statement of urgency or statement on urgent matters to be made. That was when he registered the minority's strong opposition to this letter coming from Parliament to the EC declaring the Kpandai seat vacant. He made the point that the Speaker himself, Alban Bagbe, in the last ruling on this matter, indicated that he was not going to declare the seat vacant because there is a pending application in court, stay of execution in court. And so he questions at what point Parliament revert from this position and wrote that letter to the question whether this had been the position of Parliament if it was a majority MP involved. Let's listen to him.
The question that naturally arises is, why has the principle changed? What explains the abrupt departure from the binding reasoning you articulated on 24th November 2025? Why does the stay rule apply in one circumstance but not the other, particularly when the factual and procedural posture is virtually identical? Speaker, Ghanaians are asking, and we in this House must also ask, is this because Honorable Matthew Nyendam is a member of the New Patriotic Party? The Speaker, the law does not discriminate. The law does not bind or stiffen binding on whether an NPP or NDC member stands before it. If we abandon principle today, we leave the future Parliament with a trail of inconsistency that invites retaliation, weakens the authority of Speaker's chair, and erodes public trust. Mr. Speaker, we must do better, and this House must do better, and we must act better. The legitimacy of Parliament depends on our consistency, and we can't do otherwise. And consistency depends on our willingness to obey not our political impulses, but the clear dictates of the law.
So this was the minority chief whip, Arnold Dompré, there making that point on the floor. But James, the minority then went ahead to make some specific demands. What are they? James, if you can hear me, kindly unmute so we can hear what you're telling us.
Brace, I'm indicating that The position of the minority at this point is simple. The House must revert that directive to the Electoral Commission. That letter must be withdrawn with immediate effect, failure of which they will not allow any business of the floor to proceed.
Speaker, we strongly submit that the letter that was filed to the Electoral Commission was out of place, was unfortunate, and flies in the face of law and procedural justice. We submit strongly to this House that that letter must be withdrawn by Parliament forthwith, and we must act and stay consistent with the pronouncements of the chair, for that matter, the Speaker, on this same matter. We in the minority do not agree to the writing of this letter. We make a strong position that that letter must be withdrawn forthwith. And as a cradle of democracy, we must be seen to be setting a very good example for the populace of this country to follow suit. Speaker, I submit to you that that letter must be recalled. That letter declaring the Kpandai seat vacant must be recalled immediately. It must be recalled immediately. It cannot be. It cannot be. The situation cannot. And we on this house, on this side of the house, cannot support that decision. Ghana is a fledgling democracy, and the least we can do is to support procedure, is to support the provisions of our law, and to stay away from decisions that flies in the face of logic and procedural justice. We are totally against it. In this house, we have worked in collaboration and in cooperation with our colleagues in the majority. Even where you don't have your numbers, we have allowed you to lay papers and do all manner of things. This decision will not stay. This decision will not stay. And Speaker, we humbly call upon you to instruct the clerk. The clerk must be instructed forthwith to withdraw that letter and act according to law. I so submit.
Well, James, I mean, we know that this had generally been a smooth proceedings. At what point did it degenerate into that prolonged protest that we saw?
Brace, so right after the minority chief whip made those pronouncements, the entire membership behind him, who were cladded in black, all wearing black nose mask, in anticipation of this protest, rose to their feet, chanting patriotic songs. At a point, they were chanting that Jethro must go, referring to the clerk of parliament, calling for his resignation. They also, at a point in the chant, indicated that they will not support any third term of the president, John Mahama. It's unclear at what point that came into the discussion, but indeed, some of the papers, the placards they were hurling on the floor of parliament had the inscription, quote, "We can see through your third term agenda, dark days for Ghana's democracy," the diplomatic institutions asking whether they can't speak on this issue. And at a point, some of this inscription even accused the president of having some influence on the judiciary, manifesting into the declaration of the High Court. This happened for close to 11 minutes until the first Deputy Speaker, Bernard Ahiafo, had to gavel and announce that they are taking a short break or a suspension of the House for the next 5 minutes.
Well, James, so all this while, the first Deputy Speaker, Bernard Ahiafo, was chairing the meeting. Then we understand in the middle of a protest, Speaker Alban Bagbin walked in, and we know that he managed to calm the minority. Is that right?
You are right, Brace, and this was after about 3 good hours of the minority leaders the First Deputy Speaker's attempt to persuade the opposition to back down on the protest, which went. He just couldn't get their audience. He sat in the chair for close to 15 minutes watching the minority continue to do what they were doing. Then we saw Speaker Alban Bagbin from nowhere walk to the floor of the House and made that substitution into the chair, taking over from Bernard Ahiafo. When he walked in, the first thing he did was to acknowledge the guests in Parliament, students who have come, who were also experiencing the spectacle that has been unfolding since afternoon. He acknowledged them, admonished them, and apologized to them on what has transpired. And he gave the order that, per the orders of the House, he's enjoined to get an official briefing from the leader of the House, which is the majority leader, before he makes any pronouncement on this. This only drew more agitation and more protest from the minority, and for about 1 hour or so, the speaker has been in and out trying to call for order. At the point, he had to employ the most extreme orders of the House, Order 1263, which enjoins him to rise to his feet in the midst of chaos and disorderliness. And when the speaker rises to his feet at that point, it becomes a signal to all members to resume their seat with immediate effect, despite what their cases. He tried that at the first time. He caught their attention. They sat down, and within this, he attempted again, and the protest continued. And when he attempted to enforce this Order 1263 the second time, it took the speaker almost 5 minutes to catch the attention of his own members, who now then resumed their seats. And at this point, the majority were also agitated, and they were also on their feet before the speaker. They had to take their seat when the speaker rose on his feet. And so that was a difficulty with the two separate speakers in calling the House to order as far as the minority protest is concerned.
Of the current situation in the House before I proceed. Yes, Majority Leader and Leader of the House.
Thank you very much, Mr. Speaker.
Honorable members. Majority Leader. Majority Leader.
Now, James, it appears this has been the strategy of the minority all along. It appears that they plan to do more than chanting and slamming the desk in Parliament.
Exactly, Brace. I spoke to a number of the minority members, and what they indicate to me is that this is the strategy for the day. Nothing will compel them to walk out of the House. Sometimes, in parliamentary politics, if your voice is not heard, it doesn't matter which side of the House you come from. What they do is to stage a walkout. Honorable Asafuaje from the minority indicated to me that they will not stage any walkout from today. They would continue to protest. Not even their leaders, their own leaders' persuasion will convince them to hit the call to calm down. As we speak, they have gone back to conclave with the speaker, and we expect them to come back with cool heads and for business of the day to proceed. But as far as the members are concerned, they will not back down on this protest until they get the announcement that Parliament has written another letter to the EC to withdraw that directive calling for the rerun to be held.
We know that the parties requested for this matter to be heard before the Supreme Court on the 16th of December. So we are expecting that at least that will be heard and a ruling given. So why this indecent haste? Where are we rushing to? Okay, I am completely appalled that we are doing this ourselves. We are destroying our democracy. It looks like we don't want this democracy that we have adopted for ourselves. We want some form of dictatorship, and that shouldn't be encouraged at all.
I'm interested in knowing, as counsel to the minority, what legal options are you giving your side of the house to explore to stay the hand of Parliament and the EC as far as this directive is concerned?
Well, the EC hasn't said anything yet. We know that a form of communication has been sent to the EC. We are waiting for the EC. If the EC makes any decision, we will advise ourselves. In terms of organizing an election, obviously, we will have to advise ourselves.
Go to court to lay injunction?
Yes, it's an option that will be pursued aggressively to stay the hands of the EC until the substantive matter is finally determined.
This is still top story. Let me bring in Honorable Kojo Brace. He's MP for Fosia Area, member of the minority. I'm grateful to you, sir, for joining here. Now, why not head to court, but resort to the actions that you've engaged in Parliament?
Well, we're already in court. Good evening, and good evening to your listeners. We're already in court on, I think, two different levels. First of all, there is a judicial review application at the Supreme Court, which seeks to quash what the High Court in Tamale purported to do. The High Court in Tamale purported to give itself jurisdiction over a matter on which it didn't have jurisdiction because time had run out, and then purported to issue even an order which the applicant had not asked for. And that's why we've gone to the Supreme Court with a certiorari application to quash it. Parallel to that, I think there's even another effort to stay and appeal the substantive decision that the High Court in Tamale made. Now, earlier there was a request to the Speaker to declare the seat vacant, and the Speaker relied on well-established, well-founded constitutional precedent in the Republic of Ghana to make a ruling. And his ruling was that automatically, first of all, there's a 7-day stay. Second, if the person affected files a stay and or an appeal, that further extends it until such a time that the substantive matter is determined. And we've had precedents in this country, because if you proceed to declare the seat vacant and the court rules in its favor, you have done damage that cannot be repaired. And so the position of the law has been that you let the person stay until the court finish the matter. Over the weekend, we got indication that a lot of pressure was being brought to bear on Mr. Speaker to reverse his earlier ruling. We sought clarification from the Office of the Speaker, and the Office of the Speaker informed us that there was no such truth in it. Only for us to see this letter flying on social media, purporting to be a letter informing the Electoral Commission that the Speaker has declared the seat vacant. And we are clear now in our minds that the rules of procedure are being used to perpetrate an injustice to us. And that is why it has been decided by the party and the caucus that cooperation will be withdrawn until such a time that we are assured that that letter flying around on social media purporting to declare the seat vacant is not indeed emanating from the Speaker or from the clerk. Remember that prior to this, we have been cooperating on everything. Every little report that comes as we consider the documents going towards
but if you fail to
everything has been supported.
When they have
elected to put a spanner in their own works, it is very unfortunate, but we are left with no choice than to withdraw cooperation. So that's what's happened in the chamber today. Cooperation has been withdrawn.
But won't it make it easy for them to have their way on everything they want to do?
I don't think so. We are here in the chamber. We've withdrawn cooperation, and we want the Speaker to give us that assurance that he's sticking to his earlier ruling and that he has not succumbed to any behind-the-scenes pressure as part of the efforts going on to give this government an overwhelming majority for the purposes of constitutional amendment. There's an agenda going on. At every step of the way, we tell Ghanaians there's an agenda. Many people say they don't believe it, and it is unfolding. And we are saying that Unfortunately, we've been left with no choice than to withdraw cooperation until Mr. Speaker gives us that assurance that that letter is not emanating from him.
So is it our understanding that you'll be in the House, but you make it difficult for the majority to have their way?
Well, we have withdrawn cooperation. You recall that we're cooperating. There are various ways of cooperating. Unfortunately, we've had to withdraw cooperation because we are left with no choice than to withdraw cooperation until such a time that Mr. Speaker makes that declaration.
Okay.
He's made the ruling already. No pressure should be brought on Mr. Speaker to renege on his ruling. No pressure should be brought on the courts to cause them to do this injustice to the thousands of people in Kpandai who voted for the Honorable Matthew Nyindam to be their representative in Parliament.
Okay.
No amount of pressure should be brought on them. And the least that we can do as 87 other reps or 86 other reps in the House is to stand up for the people who stood in queue that day to vote in Kpandai, whose vote is today being taken away because of the political maneuvers being brought to bear on Mr. Speaker and on the courts. The least we can do is to stand for them, and that's why we're having to do this.
Do stay with me. Let me bring in Inus Afuseni, former MP for Tamale Central. I'm grateful to you, sir, for joining. Now, isn't it right, or couldn't Parliament have waited for the court processes to be completed before it takes the step that it has taken?
Well, thank you for having me. I have listened to my colleague on the other side, and I think that the approach they have adopted appears to me to be extrajudicial, extra-legal, mostly founded in parliamentary practice.
Why is that extrajudicial, extra-legal?
The matter is a matter that resulted from a decision of the High Court Tamale, annulling the results of some polling stations in the Kpandai constituency and ordering a rerun of the election. Now, when that order is given, statutorily, that order has 7 days, within which if you read Article 1125 carefully, you have 7 days within which you can act on that order. Within that 7 days, if you file a motion for stay of execution, you either serve the notice on the clerk of parliament or you go to court to pray on the court to abridge time for you to move your motion for stay of execution because of the consequences of that could follow from such a ruling. Now, when you serve the motion on the clerk of parliament, the clerk of parliament would have to respect the court process and so would not activate Article 1125 of the Constitution. Now, in this case, I am not quite sure whether the clerk of parliament has been served with a motion because the clerk of parliament risks disobeying or the proceedings of a court if it acted in contravention of the established rule that says that, look, if a process of court is served on you, you must restrain any further action until the matter is disposed of. Now, be it as it may, the clerk of parliament, acting on Article 1125, has written to the electoral commission, notifying the electoral commission of the presence of a vacancy in parliament. Time begins to run if the electoral commission receives the letter. So if you say you are withdrawing cooperation and you are doing nothing to arrest the letter, you might end up having the electoral commission conducting a by-election.
But they are already in court with an application of certiorari at the Supreme Court. They are also appealing.
The application for certiorari does not operate to stop the operation of that order. That's what you must understand. The appeal against the decision of the High Court does not operate as a stay of execution. It's strike law. It's strike law. So you need to take steps, concrete, perceptible steps, to ensure that you stay the judgment and its effects until the final determination of the matter.
Okay, Honorable Minister Afuseni, sorry, forgive me, but stay on. Let's take you to Parliament now. We understand the Speaker, Alban Bagbing, is on the floor speaking on this particular matter.
Minority Leader.
Thank you, Mr. Speaker. Mr. Speaker, the issues before this House have to do with a letter written by the clerk of the Parliament to the Electoral Commission dated 4 December 2025. In the letter, the clerk, Ebenezer Ehuma Jetro, had written to the chairperson of the Electoral Commission, and it reads, occurrence of vacancy in the membership of Parliament. And it said, in exercise of the powers conferred and the duty imposed on the clerk to Parliament by Article 112, Clause 5, as amended, of the occurrence of a vacancy in the membership of Parliament, occasioned by the order of the High Court, Tamale, for a rerun of the Kpandai parliamentary elections, given on the 24th day of November 2025. This notification is pursuant to the service of a court order on the clerk to Parliament as the fourth respondent in the suit numbered NR/HC/E13/22 order on the clerk to Parliament as the fourth respondent in the suit numbered NR/HC/E13/22/25. Accordingly, notice is hereby given. Mr. Speaker, on the strength of this communication from the clerk to the chairperson of the Electoral Commission, the minority today, this morning, made a statement pursuant to the provisions on statements on urgent public matters. Mr. Speaker, when the minority chief whip made a statement, he demanded that the clerk be made to withdraw the letter he has written to the Electoral Commission. Mr. Speaker, I was not in the chamber at the time that the statement was made by the minority chief whip. I came in and I saw that the majority chief whip was on his feet and the members of the minority were on their feet behaving the very way that they are behaving now. And so I then urged the minority to allow for comments to be made, but they persisted behaving the way that they are behaving right now. Mr. Speaker, they continued behaving this way until the first deputy speaker, who was presiding, decided to get up on on his feet to try and then bring order in the House. Mr. Speaker, he stood for a very long time, and they did not. They continued conducting themselves in the manner that they are conducting themselves now. And so the First Deputy Speaker took a short suspension and invited the leadership to conclave. When we went into conclave, the minority leadership refused to show up. They refused to show up, and subsequently, Honorable Habib came and said he had been mandated by the leadership to represent them in conclave. So in conclave, we tried to discuss the situation and to find out exactly what the problem was. It turned out, Mr. Speaker, that they said on the 4th, on Thursday, 27th of November, 2025, you had given a ruling regarding the rerun of the Kpandai parliamentary elections. And in your ruling, according to them, you had indicated that if the member for Kpandai exercised his rights to appeal, then that exercise of the right to appeal against the High Court decision will act as a stay on the execution of the orders or the judgment of the court. So the member for Kpandai had gone to file an appeal and had also filed an application for stay. And so, according to them, having acted on your indications in the chamber, they felt that the decision to allow the clerk to write to the chairperson of the Electoral Commission was not in good faith, and that was the basis of their objection. I listened to them, and so I called for the records, and I was given the Hansard, which captures exactly what you said on Thursday, 27th of November 2025. And Mr. Speaker, I want to read excerpts of your ruling and where they are basing their claims on, and then my responses to them. Mr. Speaker, you indicated on that day that honorable members, on Tuesday, 25th November 2025, the Legal Services Office of the House was served with an order from the Tamale High Court directed at the clerk to Parliament. Per the order, the court had ordered the second respondent, that is the Electoral Commission, to rerun the Kpandai parliamentary election within 30 days. Honorable members, this order arises out of the election petition filed by Daniel Nsal Wakwal, challenging the declaration of the Electoral Commission of Matthew Yindam as Member of Parliament elect for the Kpandai constituency pursuant to the Kpandai parliamentary elections held on 7 December 2025. Honourable members, the effect of the order, to my understanding, is that the Electoral Commission is to conduct a rerun election within 30 days, implying that the original declaration of Honourable Matthew Yindam as the winner of the parliamentary election is invalid, and the member is no longer a member of Parliament. however, bring to the attention of the House the provisions of the Court of Appeal Rules 1997 CI 19 as amended in the Court of Appeal Rules of 2020 CI 132 Rule 27.3, and it provides as follows, and I quote, "There shall be a stay of execution of the judgment or decision appealed against for a period of 7 days immediately following the giving of notice of the judgment or decision." This rule appears mandatory in 8 terms and applies in every High Court decision capable of appeal. The Supreme Court in Mensa and Ghana Commercial Bank 2005 to 2006, Supreme Court of Ghana Law Reports on page 288 held that any execution commenced before the expiry of this 7-day period is premature and void. The Court of Appeal reaffirmed this position in Clenham Construction Limited and Falcon Crest Investment Limited and others, 7 April 2022, emphasizing that the purpose of the statutory stay is to allow the losing party the opportunity to consider the judgment and determine whether to appeal or seek further relief. Justice Boakye explained that the position of the law thus, and I quote him, "The plain meaning, scope, and effect of Rule 27.3b of CI 19 is that in respect of any ruling, judgment, or decision of the High Court of whatever description, in respect of which an appeal can be filed, and further, in respect of which an application for a stay of execution or proceedings could be filed, there shall operate a statutory stay of execution or proceedings for a period of 7 days. The apparent intent of the law is to enable the vanquished to ponder over and scrutinize the bona fides of the ruling, decision, or judgment in order to decide on whether or not to appeal. It is when a decision is made to appeal that an application can be made to the High Court under Rule 27.1a of CI 19 or to this court under Rule 27.1b of CI 19. Unquote. In this instance, the ruling of the Tamale High Court was delivered on 24th November 2025. The statutory 7-day stay, therefore, remains in force until 1st December 2025. During this period, the ruling of the High Court cannot form the basis for the Speaker to instruct the Clerk to Parliament to notify the Electoral Commission that the Kpandai seat is vacant. Mr. Speaker, you then added, in addition to the above, should Mr. Yindam exercise his right of appeal, such as an application under Rule 27.1b of CI 19, it may impose a further suspension on the enforcement of the judgment until the application is determined by the appropriate court. This rule appears to prevent the subject matter of the appeal from being altered or prejudiced while the appeal processes are pending. Therefore, before the initial 7-day statutory stay, the filing of a stay application may yet introduce an additional layer that may prevent changes to the status of the honorable member within the meaning of Article 97 and 99 of the Constitution. The attention of the House is also brought to Article 105 of the 1992 Constitution, which provides that person who sits or votes in Parliament knowing or having reasonable grounds for knowing that he is not entitled to do so commits an offense, it is crucial to emphasize that Article 105 is penal in nature. Should the honorable member know that he ought not to be in the chamber and he participates in the activities in the chamber. Honorable members, it is therefore premature to say that Mr. Matuyindam is disqualified from entering and participating in the proceedings of the House, because this period still falls within the 7-day mandatory stay of execution of the order. Honorable members, this is not a declaratory order. It is an executive order that was delivered by the High Court. And so the honorable member is right to have been in the House yesterday and to have participated in the proceedings. So, Speaker, so this is what you delivered, and the minority are basing their arguments on the part of your ruling, where you said, and I quote, "In addition to the above, should Mr. Yindam exercise his right of appeal, such as an application under Rule 27(1)(b) of CI 19, it may impose a further suspension on the enforcement of the judgment until the application is determined by the appropriate court. This rule appears to prevent the subject matter of the appeal from being altered or prejudiced while the appeal processes are pending." So, Mr. Speaker, their argument is that you appear to have given a ruling that the member is entitled to stay as a member of this House, and also that if the member did file any process in the courts, by virtue of having filed the process, then the member's right to remain is further fortified until the matters are disposed of by the court where the application for stay of execution or even the appeal has been lodged. So I called for CI 19 and CI as amended by CI 132. Mr. Speaker, and I read CI 132(1) to them. And CI 132 says that the Court of Appeal Rules 1997, CI 19, referred to in this enactment as the principal enactment, is amended in Rule 27 by A, the substitution for Sub-Rule 1 of, quote, 1, an appeal shall not operate as a stay of execution under the judgment or decision appealed against unless the court otherwise orders on an application made to the court by motion on notice, unquote. Mr. Speaker, I referred my friends on the other side to this provision of CI 132 and tried to indicate to them that filing an appeal or even filing a motion on notice will not automatically serve as a stay of the execution of an order of a court. And so, in the absence of a substantive order by the court, the clerk was not stopped from communicating to the chairperson of the Electoral Commission under the Constitution, because the chairperson is also obliged under the Constitution to communicate within a certain time period. So, Mr. Speaker, I then urge on our colleagues on the other side that we should come back to the chamber and they can restate their position, and I will also state this position as I have stated it. And on the basis of our positions, then we can invite you as Speaker to come and then give a ruling whether it was appropriate or in keeping with the law for the Clerk of Parliament to write the letter that he wrote to the chairperson of the Electoral Commission, which I have already read to the chamber. Mr. Speaker, I think that it will be appropriate to read Article 112 of the Constitution so that we can see what informed the action of the Clerk of Parliament, to see whether the Clerk of Parliament is in error or also acting pursuant to a constitutional obligation. So, Mr. Speaker, with your indulgence, let me read Article 1125 of the Constitution. 1125 of the Constitution says that whenever a vacancy occurs in Parliament, the Clerk to Parliament shall notify the Electoral Commission in writing within 7 days after the vacancy occurred, and a by-election shall be held within 30 days after the vacancy occurs. Notwithstanding clause 5 of this article, a by-election shall not be held within 3 months before the holding of a general election. So, Mr. Speaker, clearly the Constitution injuncts the Clerk of Parliament whenever a vacancy occurs in Parliament. The Clerk to Parliament shall notify the Electoral Commission in writing within 7 days after the vacancy occurred, and a by-election shall be held within 30 days after the vacancy occurred. So, Mr. Speaker, so if we take the records, we notice that on 27th November 2025, 24th November 2025, you had indicated in your ruling that the statutory 7 days, stay, therefore remains in force until 1st December 2025. So once the statutory 7 days was in force till 1st December 2025, it means that the obligation of the Clerk of Parliament will start counting on the 1st of December 2025. So within 7 days of December, the clerk was obliged constitutionally, pursuant to Article 1125, to notify the clerk. So on the 4th of December, the clerk wrote to the Electoral Commission indicating that there was a vacancy because the clerk had been served by the order emanating from the High Court indicating that the court had ruled that there should be a rerun of the election in the Kpandai constituency. So, Mr. Speaker, I think that what you are being invited to rule on here today is whether the clerk erred in communicating to the Electoral Commission that a vacancy has occurred, and once a vacancy has occurred, that there should be a by-election in the Kpandai constituency. Mr. Speaker, especially your indication in your ruling that filing an appeal may elongate the period during which the member may be allowed to remain in the chamber. So, Mr. Speaker, that is basically what it is. That's all. Nothing really earth-shattering. And since morning, we've been having indications, negotiations, discussions, and we said that we should come into the chamber, and since they have indicated their position, we should also indicate our position. Now, in a normal democracy, with normal Democrats, people who actually believe in democracy, you would imagine that they will have no issue with us having this discussion in open parliament. But Mr. Speaker, I'm not surprised that we have this character of parliamentarians representing the minority side, and they are insisting that they don't want the discussions held in open parliament, that we should not be transparent about our arguments, that this side of the House should not be heard on this matter. And I have said it's not possible. No matter how much you chant, no matter how much noise you make. In fact, even if you come and stand on my seat here, I will still state my position so that the Speaker can give his ruling. So, Mr. Speaker, the issue before you is not to challenge your ruling. It is not to challenge your ruling, because your ruling was not even about what happens when one files an appeal. Your ruling was whether or not within the 7 days you could be called upon to remove the member of parliament from the chamber. If you recall, that was the main issue. And you ruled accordingly that by our CI 19, there is an automatic stay for 7 days. And so within that 7 days, the judgment could not be executed. The member will have a right to be in the chamber. But after the 7 days, then execution will be triggered automatically. So that ruling you gave, but then you engage in a general discussion of, some legal matters, and then you said that, if he triggers his appeal rights, it may. I think that the contention is around your use of the word may, and having used the word may, their position is that once he had filed his appeal and filed his motion on notice trying to secure an interim injunction, then we should not have allowed the clerk to write the letter to the Electoral Commission. But my contention is that that was not the gravamen of your ruling. The gravamen of your ruling was basically to decide that on that day the honourable member should stay in the chamber or not. And you did rule that he could stay in the chamber. Now, the issue of whether or not when he files an appeal and when he files a motion on notice for interim injunction, whether that serves as an injunction is a completely different matter. And I drew attention to CI 132, which amended CI 19, and which in its terms is very clear that once judgment is given, when you file an appeal or a motion on notice for stay of execution, it does not automatically stay proceedings in the execution of that judgment. So, Mr. Speaker, this is what you are being called upon to decide, and unfortunately, I am surprised that our friends on the other side will not want this fact to be stated, so that Ghanaians will know why they are in black. Ghanaians will know why they are wearing face masks. They don't want Ghanaians to identify them individually. They are wearing face masks. They are wearing face masks. They don't want Ghanaians to identify them. If you are ashamed of what you are doing, remove your face mask. If you are ashamed of what you are doing, then don't do it. If you have the courage to do them, don't wear face masks to do them. I I'm not wearing a face mask. I am very confident. And I can assure you that I will not be distracted. You can say anything about Boku, I will not respond to you. You can say anything, I will not mind you. I will remain focused. I will let the Ghanaians know that you are only pretending to be Democrats. You are not Democrats. Because if you are Democrats, you will allow Ghanaians to hear what is it that you are fighting. But you don't want Ghanaians to hear the facts because you know that the facts are not on your side. You are fighting for justice, but you don't want Ghanaians to know the facts on the basis that you are fighting for justice. How will the Speaker rule if the Speaker has not heard all sides of this matter? The Speaker cannot rule. That is why since morning, my side has insisted that we will speak to the facts so that the Speaker can rule on the matter. And I am insisting that we will not allow this matter to be treated in secrecy. It must be treated in the full glare of the media. I want them to capture the facts based on which you are mounting your protest so that Ghanaians will be the judges as to who actually is right in this matter. So, Mr. Speaker, basically, those are the facts. And I hear them talking about Boku. I will restrain myself today because His Royal Majesty, Botumfo, has indicated that he will bring the report on Boku on the 17th to present to His Excellency the President. When he presents his report to His Excellency the President, we will see where the matter will end. Mr. Speaker, on that note, I thank you very much.
Honorable members, honorable members, I believe the office of the official reports would have captured what the majority leader commented upon. Honorable members, I will have to, in the circumstances that we are in today, have access to what has been captured by the official reports, and I will come to the House to give a ruling in this matter. Honorable members, in the circumstances, I will want to urge the House to await my ruling and to allow us to proceed with the business of the House. I'm reliably informed that this was an urgent statement that was made by the minority chief whip. And so I think this matter would have come under item 8. And being an urgent statement of public concern, the First Deputy Speaker granted leave after the indulgence of the House. And so the rules were properly applied. It means after item 8, subject to the convenience of the House, I want us to take item 9, which is at the commencement of public business. Item 9, presentation of papers. Yes. Yes.
Mr. Speaker, item 9A is request for tax waivers to be laid by the Minister for Finance. Mr. Speaker, the Minister of Finance is not immediately available, and so I want to crave your indulgence for his deputy who is here, to lay item 9A.
Yes, minority. Honorable members, I thought I saw, honorable members, minority chief whip was on his feet, so I have to listen to him. Yes, minority chief whip.
Speaker. Don't let me speak.
Yes, minority chief whip.
Speaker, my colleagues should bear me out. All the occasions that it matter, we had cooperated. If you're a man, speak into the microphone, and we'll reply you. So, you can say whatever you want to say. No, but let me make it very clear. You cannot scare me. You cannot scare me. Whatever I want to say, I'll say it. If you want to speak, rise up and catch the eye of the speaker. You cannot scare me. You can't. What can you do? Speaker, I'm saying that to the extent that since we started the consideration of the estimate, largely we have cooperated with our colleagues. Even where ministers are absent, where committee chairs are absent, we have cooperated and staged the needed compromise. Speaker, we've had enough for the day. And hence, we will
call for an adjournment, a due and adjournment, and a deserving one, of course. We are calling for an adjournment because well, for the records, we want to make it very clear to you that you cannot scare anybody here. Now, until Kpandai is resolved, government business will suffer. Get away! Get it fair! Get it fair! Until Kpandai, I put it to you, that until Kpandai is resolved, government business is going to suffer. And from henceforth, you keep telling us you have 189, 185, and then 4 independent members. Go and marshal your numbers and come and do your business. Until Kpandai is resolved, we on this side will not cooperate. We are saying it again, we will not cooperate with you. Nobody's going anywhere. Well, we are not moving. We are not going anywhere. And so, Speaker, we have made our point, and we will continue to make this point. We are not obstructing government business. Now, we believe that governance is a continuum, and we must continue with government business. However, to the extent that you want to twist our hands, to the extent that you have conspired to twist our hands, I put it to you that government business will suffer. So, we are not doing any business. We are not going to cooperate with you until Kpandai is resolved. And we are telling you this. Chief will get it. Government business will suffer, and you are going to suffer. And if you think we are going to go home, nobody is stepping out of this chamber. Nobody is moving out. So, Speaker, we have had enough for the day. We must deservedly adjourn. And then when we come tomorrow, we will consider whether we'll do business with you or not.
Honorable members, I put the question. Those in favor of adjournment, say aye. Those against adjournment, say no. Honorable members, the noes have it. So, yes, Deputy Minority Whip.
Mr. Speaker, I rise under Order 1513. Mr. Speaker, I rise under 1513. Mr. Speaker, with your permission, I read Standing Order 1513. Mr. Speaker, Standing Order 151. Mr. Speaker, Standing Order 151(3) states that a member may challenge the decision of the Speaker on the voice votes, and the Speaker shall determine whether to call for a head count or electronic vote. Mr. Speaker, in this case, we call for a head count.
Honorable Majority Leader.
154. Mr. Speaker,
sure my colleague, Honorable Habib, is aware of the provisions of Order 154. Order 154 says that you cannot unnecessarily claim division. Mr. Speaker, you cannot unnecessarily claim for division. Mr. Speaker, it is obvious that this side has the numbers and we can continue to conduct business. I can understand that our friends on the other side have an issue that they want to bring to the attention of the nation. They have brought their issue to the attention of the nation. I have in my presentation to you been fair to both sides. I have really, in fact, made their case better than they could have made it themselves. So I'm sure Ghanaians know the basis of their protest. And I'm not running away from the basis of your protest. I don't easily run away. Mr. Speaker, the issue is that we have been prevented from conducting business the whole day as a result of the protest that they mounted. And we indulge them. We engaged them. I presided over a meeting that lasted several hours trying to find an amicable way out of it. Because of that, we have not been able to touch any of the items under government business. And so I urge you, Mr. Speaker, that we proceed to deal with the items. Mr. Speaker, that is my
Honourable members, it is clear that the Deputy Minority Whip has challenged my decision on the voice vote. What is now left is for me to determine whether to call for head count or electronic vote. That decision lies in my bosom, and I will exercise it in favor of us continuing the business, because I believe that the voice vote was very clear, and there was nothing wrong with my decision, and therefore we proceed with the business of the House. Honourable members, item 9. By the Minister for Finance. Request for the waiver of import duties, import national health insurance levy, special import levy, value-added tax, debt fund levy, ECOWAS levy, AU levy, and ESM levy on the importation of vehicles with engine capacities of up to 2.70 cc for foreign service officers returning from imposting at Ghana mission abroad. Honourable members, the requests for the waiver of the duties, taxes, and levies are accordingly referred to the Committee on Finance for consideration and report to the House. Yes.
Mr. Speaker, item 9B is brought to this House by the Minister for Foreign Affairs. Mr. Speaker, Mr. Mr. Speaker, the Deputy Minister for Foreign Affairs is in the chamber, so I want to crave your indulgence for the Deputy Minister for Foreign Affairs to lay item number 9B.
Honorable members, item 9B by the Minister for Foreign Affairs.
Agreement on the United Nations Convention on the Law of the Sea, UNCLOS, on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction.
Please, the Minister.
Honorable members, the said agreement has been accordingly presented to the House and is referred to the Committee on Foreign Affairs for consideration and report to the House. Yes, Majority Leader.
Yeah, Mr. Speaker, item number 9C is by the Minister for Energy and Green Transition. Mr. Speaker, the Minister for Energy and Green Transition is unavoidably absent, and so I crave your indulgence for his deputy, the Deputy Minister for Energy and Green Transition, who is in the chamber, to lay the work program of the Ghana National Petroleum Corporation on behalf the Deputy Minister for Lands, to lay the paper on behalf of the Minister for
Honorable members,
the Minister for Energy and Green Transition,
GNPC, for the year 2026. Honorable members, item 9C. Work program of the Ghana National Petroleum Corporation, GNPC, for the year 2026. Honorable members, the work program of the Ghana National Petroleum Corporation for the year 2026 has been presented to the House and referred to the Committee on Energy for consideration and report to the House. Honorable members, we now move to item 25.
Mr. Speaker, we will now take item 25. Mr. Speaker, I crave your indulgence so that the Deputy Minister for Lands and Natural Resources, Honorable Yusuf, will move the motion, and then we can take the motion, Mr. Speaker.
Honorable members,
Mr. Speaker, the chairman of the committee will move the motion.
Honorable members, item 26 is supposed to be presented by the chairman of the committee. Mr. Speaker, I beg to move that this House the report of the Committee on Lands and Natural Resources on the allocation of the sum of 2,108,555,490 Ghana cedis for the services of the Ministry of Lands and Natural Resources for the year ending 31st December 2026. I so move.
Mr. Speaker, Mr. Speaker, Mr. Speaker, I write to second movements. Any seconder. We will allow any seconder. Mr. Speaker, I rise to second the motion heavily moved by the chairman of the Committee of Lands and Natural Resources. And in doing so, Mr. Chairman, I want to call on this House to adopt this motion and pass the amount of money stated in this motion for the Ministry of Lands and Natural Resources and its agencies. Thank you. It's wrong. Motion moved and seconded is for the consideration of the House. Mr. Speaker, I think you can put the question. Honorable members, there be no consideration. I'll put the question. Those in favor of the motion say aye. Those against say no. Honorable members, the ayes have it. The motion is accordingly adopted. These are the views of the majority. Mr. Speaker, we will take item number 18, which is the Ministry of Labor, Jobs and Employment. Mr. Speaker, so we'll take item number 18. Item 18. Motion. Chairman of the committee.
Okay. Yeah, I have it here. Thank you, Mr. Speaker. Mr. Speaker, I rise to second the motion and which moving? You move it.
Mr. Speaker, I move that and doing so, present your committee the report. Mr. Speaker, I urge the Hamza department,
both the minority and the majority MPs pushing and pulling it together. There's a the scaffold that is breaking on the floor now of Parliament as we speak. Both the majority and the minority MPs now pushing and pulling each other on the center of Parliament, and it's unclear how the marshals will resolve this, but you see the marshals there now standing watching what is happening. And for those who just watching, the minority MPs proceeded from their seats. They moved from their seats to the center of the floor in an attempt to distract the happenings. You see the majority MPs shouting push as they push the minority MPs to go back to their seats now. It's a scaffold that has broken between the two sides of the House. The members of Parliament from both sides pushing and pulling each other as the minority move from their seats in an attempt to distract the proceedings of the House. The majority rose to their feet. They will not take anything of a sort from the minority. They have moved to make sure that the minority occupies their seat, go back to their seat, and allow the business of the House to proceed, allow the Parliament to proceed with their business. Before what we are seeing now, the majority was proceeding with a business. A number of reports have been laid. The Lands Committee have laid a report calling for the allocation to the Lands Ministry to be adopted. The Speaker went on to adopt that, and they were proceeding with other reports of the House. And the minority were still chanting, calling for the proceedings of the House to come to a halt. The majority and the Speaker will not take any of that. And at a point, some few minutes ago, they all moved from their seats to occupy the center of the House in an attempt to prevent the proceedings to continue. As we speak, they are mingling among each other. It's unclear what happens to the provisions of the House that bars members from crossing over to the other side, which we call carpet crossing. It's unclear what happens to that provision of the House now, and whether the Speaker will be pronouncing on that. You see the marshals in the midst of the MPs trying to separate them and encourage them to take a seat. At a point now, both minority and majority MPs are hugging each other. It looks like they have understood, come to a consensus now. You see MPs from the minority hugging MPs from the majority, and it's unclear whether the minority will resume their seat, but the indication they gave in now is that they would continue to occupy the space in the middle of the House. They will not be retreating to their seat. They are continuing with a chant in protest to make their protest stand. You see the majority leader, Mahama Yariga, still reading to the Speaker, indicating that the proceedings of the House must continue. The business of the House must continue. Al-Hassan Suhini there also indicating to the table office to give audience to the majority leader, Mahama Yariga, and listen to him, hear from him as he moves for more reports to be taken, more reports from the committees should be taken and approved as the House makes an attempt to adopt the report of the committees and approve the allocations of the finance minister to the various ministries. That is what the majority are still trying to push now, as the minority still occupy the center of the floor. You see the marshals now have built a wall around the minority trying to prevent them from proceeding any further. The marshals of the House have built a human wall around the minority, preventing them from making any further step to distract the proceedings of the House. You see there, Honorable John Dubello also moving to the center of the floor, appealing to the minority to occupy their seat. The marshals have indicated to him that they are on top of the issues. They are on top of the issues, and that he should resume his seat. He has retreated now. The Deputy Lands Minister and MP for Bamboy, Honorable Yusuf Suleimana, also urging his members to calm down and take their seats, and that the business of the House will proceed regardless what the minority is doing now. The minority have now resolved to stay on their feet now in the middle of the floor of Parliament. The banging of the table is still continuing as they continue their protest against the proceedings, the business of the House from continuing against the majority executing the business of government on the floor. There was scuffle between the two sides, the majority pushing the minority in to resume their seats, preventing them from distracting the proceedings of the House. The minority would refuse, they will not budge to that. They are occupying the middle of the floor of the House as part of their protest. The Speaker of Parliament, Alban Bagdin, is trying every means possible to get some order to the floor so that the proceedings can progress. For those just joining us, Parliament some few minutes ago was in chaos as both sides of the House engaged in exchange of words and pushing and pulling of each other to register their protest as a minority moved to occupy the center of the House. But as we speak,
has been moved and seconded. Since there is no further consideration, I put the question. Those in favor of the motion, say aye. Those against, say no.
Item number 19.
Honorable members, the ayes have it. The motion is adopted.
No, 19. You have to repeat it. Where's the minister? No, he says that he didn't put the question. Of the Committee on Employment, on Labor, Jobs and Employment and Pensions, on the allocations of the sum of 26,648,670 Ghana cedis for the services of the National Labour Commission for the year ending 31st December 2026. Mr. Speaker, so moved. Where is the chairman? Come back here. Where's the chairman?
I don't know who has seconded the motion. Please, you have not disclosed who you are. Who seconded the motion?
Right, Honorable Speaker, I am the Vice Chairman of the committee, and in seconding the motion, I'm the Vice Chairman of the committee. My name is Isaac Ashai